Quickie Simulator. This one might have a silly name, but sadly, it's a very serious subject. In December of 1997, a 14-year-old boy opened fire on a group of his fellow students at Heath High School in Kentucky, killing 3 and wounding 5. He stopped shooting, surrendered to the principal, and said, "Kill me, please. I can't believe I did that." Afterwards, he was diagnosed with paranoid schizophrenia. He's now serving life without parole. Okay, depressing part's over, I promise. Jack Thompson is a now-disbarred attorney who was one of the leading charges against freedom of speech, including video games, rap music, and pornography. He convinced the grieving parents that the thing they needed to do was to sue Deep Pockets, and he chose Meow Media, makers of Doom, Quake, Resident Evil, and other video games. Thompson claimed that the video games and movies he watched from Meow Media desensitized him to violence and directly caused him to kill his fellow students. The district court threw out the case, saying that the students' violent actions weren't in any way foreseeable, and therefore there wasn't a duty of care. Further, if such a duty of care existed, the nature of the media didn't comprise a product that could be defective. They also threw out the RICO claim Thompson laughably filed against them. The Sixth Circuit affirmed it. They ruled, "We find that it is simply too far a leap from shooting characters on a video screen, an activity undertaken by millions, to shooting people in a classroom, an activity undertaken by a handful at most." The principle is, you're not responsible for what a crazy person does in response to you. Even if it can be certain that there are crazy people out there, by definition, their actions are unforeseeable. Of course, they cited the absolute First Amendment problems, quote, "Because the plaintiffs seek to attach tort liability to the communicative aspect of the video games produced by the defendants, we have little difficulty in holding that the First Amendment protects video games in the sense uniquely relevant to this lawsuit." They also ruled, "By imposing liability on those who did not endeavor to accomplish the intentional criminal undertaking, tort liability would diminish the responsibility placed on the criminal defendant. The normative message of tort law in these situations would be that the defendant is not entirely responsible for his intentional criminal act." In every case that this court has discovered in which defendants have been held liable for negligently creating an unreasonably high risk of third-party criminal conduct, the defendants have been specifically aware of the peculiar tendency of a particular person to commit a criminal act with the defendant's materials. The Supreme Court denied certiorari, most likely because this principle is too well established to be a controversy. But given what some are trying to do with gun manufacturers today, maybe it's time they weighed in on it. In every case that this court has discovered in which defendants have been held liable for negligently creating an unreasonably high risk of third-party criminal conduct? Oh my god, I should get an award for that one.